Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from New York. In today's video, I'm going to go in a little bit more details about the immigration reconciliation proposal and text of it. I'm going to cover who potentially may qualify for immigration reform in the United States, what the state of it right now, and what you need to do to prepare for it. So if it's your first time here, welcome. Please subscribe to my channel, like and share this video. Don't forget to comment, and let's start. As you know, there is a lot of talk right now and hopes for immigration reconciliation bill. In fact, the proposed text of the law was just revealed this past Sunday. Something that we all were waiting for to find out who may qualify for immigration reform in the United States, that we all are waiting for. And I'm going to discuss right now who, out of all the immigrants in the United States, potentially may have a chance of getting green cards in the United States. Well, first of all, the proposal does not discuss citizenship directly. It's not what it's all about. The proposal does discuss green cards or adjustment of status. We're talking about people finally being able to receive green cards in the United States. And we're going to talk about how to qualify for it. Well, first of all, the proposal is just a proposal. It's not the law yet. There is nothing to apply for at this very moment. The final text of the law, if it will come to that point, may change as well. But here are the people, here are the groups of people who may qualify for this under this proposal for the reform. The dreamers, the essential workers, and the TPS holders. To qualify for the proposal, to be able to apply for this adjustment of status that will be newly created by the Immigration Reconciliation Bill, if it passes, a person will have to pay $1,500 or $1,500 fee, will have to, of course, pass background checks, and the person will have to show that they're not otherwise inadmissible. Points I'm going to cover a little bit later. So right now, let's talk about dreamers. Who is a dreamer? People ask me questions. Will DACA holders qualify? Well, yes, but even if you don't have DACA, you may still qualify, because a dreamer under this proposal will be anyone who is under 18 years of age when they came to the United States and resided here continuously since then. When they resided in the United States physically as of January 1st, 2021, and they have to show that they have a record of honorable service in the United States military, or they completed at least 2 years towards a degree or a technical school, or they, in the past 3 years, they have a record of earned income and paying taxes in the United States, or they're currently enrolled in an educational program and they're also doing internship or have employment. So this is who will be considered a dreamer, a person who can qualify for this particular proposal. But you may encounter the word dreamer in other proposals or in other articles. So you always have to look in the text of the law, specific law, to determine whether you meet the criteria under this particular law and what this particular law means when they call somebody a dreamer. So I just explained to you who they believe are dreamers under this particular proposal currently. Then the TPS holders. We have TPS holders, but not just any TPS holder or TPS eligible person, but a person who was a TPS holder or was eligible for TPS if the TPS status was designated at least on January 1st, 2017. So people who were recently designated, or nationals who were recently were able to apply for TPS will not qualify, like people from Venezuela or Haiti under the new redesignation provisions. And it's a problem that potentially will be fixed. We do not know, but potentially may be fixed. Maybe they will fix it to the point that you have to show you resided in the United States since that time, but now you are applicant or TPS holder. We do not know. But I'm commenting on the language of the proposal that is out there right now. Again, it may change. And finally, one more group. This is the largest group, essential workers. You will be able to show that you're an essential worker if from the period of January 31st, 2020 through August 24th, 2021, you had a consistent record of income, of earned income in certain occupations. And the list of those occupations is published by the government already. It was published on August 10th, 2021, and I'm going to post a link to that publication because the definition of an essential worker under those guidelines is very, very broad. Anybody pretty much who worked during the COVID time will meet the definition of essential worker. All right, and you will be happy to find out that it's a very, very broad definition. People in healthcare industry, not just nurses and assistants to doctors, but also those who provided administrative support will qualify, for example. Those who are providing cleaning services will qualify, and so on and so forth. People in constructions and transportation, you will see if you read that list, if it's quite broad, so you'll be very happy. Now, it's estimated that the proposal is going to help about 8 million people in the United States and about 500,000 in New York, the most people from California, Florida, Texas. So we're going to see what is happening with the proposal now. I'm going to go back to it in a little bit after I explain to you who may not qualify. If you meet all those definitions, you still may not be able to achieve your dream if you have certain criminal convictions. For example, if you were convicted of a crime with a potential sentence of imprisonment for more than a year, or if you have convictions of 3 separate crimes with imprisonment of 90 days, you will not qualify unless a waiver is granted, a waiver for humanitarian purpose of family unity or public interest. We do not know specific qualifications that will be needed to be demonstrated to qualify for those waivers, but it gives us some sort of understanding that a waiver will be available, at least a chance, right? So that's good. Now, people with outstanding orders of removal and people in removal proceedings, if they otherwise meet the criteria, will be able to apply for this relief as well. Very, very important. The proposal also talks about recapturing of unused visas for family immigration and employment immigration, and also it provides for a fast track if you pay a certain amount of money and you're in those categories that are stuck forever for family immigration, employment, or investment. By paying additional money, you will be able to speed up your case. It starts with $2,500 for family-based immigration, $5,000 for employment-based, and $50,000 for somebody who is an investor. I find it very good because you get a chance of getting a visa post no chance, opposed to waiting for 20 years. Let's say if you're somebody from the Philippines, you're going to be waiting for the visa. Now you can pay $2,500 and speed up the process. Fantastic, if it passes. Finally, what we do not like currently about the proposal, no mentioning about people being able to adjust status if they entered without inspection and now filing for family-based visas, right? No mentioning of dependents or derivatives, rather. Do not know. And of course, the TPS date shall be moved. I'm in agreement here with other immigration lawyers who pointed this out and believe that this proposal can be improved. I agree, it can be improved. But honestly, even if it passes the way it's written, I'll take it, as many of you will too, right? Because it gives us all a chance of finally having some resolution to this uncertainty in the United States with people's immigration status and, you know, fixing it somehow, fixing it. All right, so this is where we stand right now, but what's going on with all this good information? When it will become the law? Will it become the law? This is the main question. I'm going to explain to you right now. So right now, all I talked about is just a proposal, right? It's just a proposal. It's not the law yet. Actually, yesterday, Republicans already gave grief about it, criticizing it left and right, I believe for like 14 hours, all right? So there is a great opposition to it, but the hopes is that if the proposal will be suitable for reconciliation bill process, we don't need them. We can pass it without them. However, if it is suitable for reconciliation or not will be decided perhaps this week by the Senate parliamentarian, and she will determine if a proposal such as this one is suitable for reconciliation. So we're all waiting, hoping that she will say yes, right? Just say yes. And we will have hope that starting about May of 2022 at least, we will be able to start filing those applications for people who will qualify. Finally, what can you do to prepare for this? Well, of course, you have to follow the news and immigration lawyers and check with them on a regular basis to make sure that the bill passed and it's in fact the law and not just something that somebody from somewhere is going to tell you you can file for. You have to make sure you have reliable information. Very, very important. And get your records in place. Make sure you have your records of paying taxes and earned income. Make sure you have your birth, marriage records, divorce records, and so on. You have to have that, right? Make sure you have your dispositions for every criminal arrest that you had. And if you have any criminal charges, make sure you work with an attorney to resolve them. It's very, very important. And get copies of your immigration files and records so that a lawyer who you're going to choose to work with will make sure that you will qualify for this reform or for any other matter that you're going to be filing for. And then you should be in good shape. Well, thank you very much for watching. Please subscribe to my channel, like, share this video, stay on top of your immigration case, and I hope to see you soon.